Good afternoon and welcome everybody to the webinar on AI and individual rights. Please submit questions through the Q&A function. You will see that on your screen where I have just announced a short welcome. And if you see questions that are familiar to you, that you were thinking you may ask something similar, you can actually use the like function, and we'll try to get to those questions towards the end of the presentation. I'm handing over now to my colleague Ahmed. Thank you.
Hello everybody, welcome to this webinar on AI and individual rights. This webinar is the last in the series we've been hosting since September. You can catch up on all the previous webinars on YouTube. In 2020, the ICO has published two pieces of guidance: Explain Decisions Made with AI in conjunction with the Alan Turing Institute, and the Guidance on AI and Data Protection. This webinar will go into more detail about what each piece of guidance says about individual rights. Today we have Abigail Haxton, who will talk about the Explain guidance, and Ruben Binns and Alistair Pearson, who will talk about AI and the data protection guidance. I'm now handing over to Alistair.
Thanks, Ahmed. So I'm going to talk to you today about individual rights and how they can apply across the different stages of the AI lifecycle. So individual rights apply wherever personal data is used across the AI lifecycle. This therefore covers personal data that's contained in the training data, used to make a prediction during deployment and the result of the prediction itself, or that might be contained in the model itself. So AI creates or exacerbates issues relating to individual rights, and I'll talk a bit about them now. So identifying the individuals that the training data is about is a potential challenge to ensuring their rights. Typically, training data only includes information relevant to predictions such as past transactions, demographics, or location, but not the contact details or unique customer identifiers. So the training data is also typically subjected to various measures to make it more amenable to machine learning algorithms. So for example, a detailed timeline of a customer's purchases might be transformed into a summary of peaks and troughs in their transaction history. So here what's happening is you're converting personal data from one form into a potentially less detailed form to help the training algorithm. So this could make it much harder to link it to a particular named individual, but this doesn't necessarily take it out of the data protection scope. So therefore you'll need to consider this data when you're responding to individual rights requests to exercise their rights. Even if the data lacks associated identifiers or contact details and has been transformed through pre-processing, training data may still be considered personal data. This is because it can be used to single out the individual it relates to on its own or in combination with other data you may process, even if it cannot be associated with a customer's name. So for example, the training data in a purchase prediction model might include a pattern of purchases unique to one customer. In this example, if a customer provided a list of their recent purchases as part of their request, the organization may be able to identify the portion of the training data that relates to them. In these kinds of circumstances, you are obliged to respond to an individual's request, assuming you have taken reasonable measures to verify their identity and no other exemptions apply. There may be times when you are not able to identify an individual in the training data directly or indirectly. Providing you are able to demonstrate this, individual rights under Article 15 to 20 do not apply. However, if the individual provides additional information that enables identification, this is no longer the case and you will need to fulfill any request they make. You should consult our guidance on determining what is personal data for more information about identifiability. We recognise that the use of personal data with AI may sometimes make it harder to fulfill individual rights to information access, rectification, erasure, restriction of processing, and notification. If a request is manifestly unfounded or excessive, you may be able to charge a fee or refuse to act on the request. However, you should not regard requests about such data as manifestly unfounded or excessive, just because they may be harder to fulfill in the context of AI, or the motivation for requesting them may be unclear in comparison to other access requests you typically receive. If you outsource an AI service to another organization, This could also make the process of responding to rights requests more complicated when the personal data involved is processed by them rather than you. When procuring an AI service, you must choose one which allows individual rights to be protected and enabled in order to meet your obligations as a controller. If your chosen service is not designed to easily comply with these rights, this does not remove or change those obligations. If you are operating as a controller, your contract with the processor must stipulate that the processor assists you in responding to rights requests. If you're operating an AI service as a joint controller, you need to decide with your fellow controllers who will carry out which obligations. Typically, once deployed, the outputs of an AI system are stored in a profile of an individual and used to take some action about them. So, for example, the product offers a customer sees on a website might be driven by the output of the predictive model stored on their profile. Where this data constitute personal data, it will generally be subject to all of the rights mentioned above, unless exemptions or other limitations to those rights apply. Whereas individual inaccuracies in training data may have negligible effect, an inaccurate output of a model could directly affect the individuals. Requests for rectification of model outputs or the personal data inputs on which they are based are therefore more likely to be made than requests for rectification of training data. However, as we've said previously in the webinar on statistical accuracy, predictions are not inaccurate if they are intended as prediction scores, as opposed to statements of fact. Therefore, if the personal data is not inaccurate, then the right to rectification does not apply. I'll now briefly talk about how individual rights relate to data contained in the model itself. So this is for models such as support vector machines, which can contain some key examples from the training data in order to help distinguish between new examples during deployment. In these cases, a small set of individual examples are contained somewhere in the internal logic of the model. The training set typically contains hundreds of thousands of examples, and only a small percentage of them end up being used directly in the model. Therefore, the chances that one of the relevant individuals makes requests are very small, but remains possible. If the request is for access to the data, you could fulfill this without altering the model. If the request is for rectification or erasure of the data, this may not be possible without retraining the model or deleting the model altogether. To prevent difficulties of this in your organization, we recommend as best practice for you to have a well-organized model management system and deployment pipeline, which will make it easier and cheaper to accommodate these requests, and retraining and redeploying your AL models accordingly will be less costly, although this is not a legal requirement. Also, how sometimes data in the model may be leaked by accident. So aside from some models that contain examples from the training data by design, some models might leak personal data by accident. In these cases, unauthorized parties may be able to recover elements of the training data or infer who was in it by analyzing the way the model behaves. The rights of access, rectification, and erasure may be difficult or impossible to exercise and fulfill in these scenarios. Unless the individual presents evidence that their personal data could be inferred from the model, you may not be able to determine whether the personal data can be inferred and therefore whether the request has any basis. You should regularly and proactively evaluate the possibility of personal data being inferred from models in light of the state-of-the-art technology so that you minimize the risk of accidental disclosure. I'll now hand over to Ruben, who will talk more about rights associated with solely automated decisions with legal or similar effect.
Thank you. This part of the guidance covers situations where you have an AI model which is making decisions about people, and where it's within the scope of Article 22, which says that if a decision is solely automated and it has legal or similarly significant effects on the individual, then there are some additional safeguards and consequences for compliance. So those include Articles 13 and 14, which talk about information that has to be given to the individual, meaningful information about the logic involved in processing, as well as the significance and the envisaged consequences. Abby will be talking more about this later on. Article 15 also says you have to provide the same information in response to a subject access request. Article 22(3) gives individuals a number of rights, including the right to obtain human intervention, to express his or her point of view, and to contest the decision. So even in cases where a system is designed to operate automatically and make solely automated decisions, data subjects still have the right to request human intervention. Next slide, please. So why is it important that rights related to automated decisions are considered in the context of AI? Well, machine learning systems, even when they're very good, will inevitably reach the wrong output or the wrong decision in individual cases, and so this is to be expected. And so for those cases, one of the safeguards is that individuals can exercise their rights, and so these kinds of errors could occur because the individual in question is what's called an outlier, so somebody who is statistically different to the people who the model was trained on, and therefore the model doesn't perform very well, doesn't make an accurate prediction or an accurate classification in their case. Also, in some cases, individuals may get the wrong decision because there's certain assumptions embedded in the AI system. So perhaps treating people within kind of buckets, maybe around variables like age. Depending on how broadly you bucket people, you might end up having some people at the extreme end of an age range who are inaccurately classified as a result of it. So these kinds of things mean that you may, from time to time, need to respond to requests to change the outputs that are made from ML systems that are used for solely automated decisions. So you should consider how at the very beginning of the design phase, where you're envisioning how you're going to use an AI system, think about how you're going to be able to support meaningful human reviews. So think about how the interface is going to look to the decision subject, and think about how you're going to monitor requests that come in for reviews. Make sure you design and deliver appropriate training for the people who are going to be doing the reviews, and ensure that those individuals also have the necessary level of authority and the right incentives and professional institutional support to respond to individuals' concerns, and where necessary to change the decision where the AI system has produced the wrong decision. Next slide, please. So there'll also be cases where you have an AI system that's not intended to be used in a solely automated fashion, and therefore you do not intend for it to be within the scope of Article 22. And in order to ensure that that is the case, you need to make sure that the human who is making the decision that's informed by the AI system is not just rubber stamping it, or is not just kind of applying the result of the algorithm in a routine way. So they should actually be actively checking the outputs, and their involvement should be active and not just a token gesture. So the reviewers need to actually weigh up and interpret the recommendation, but also consider other available information other factors that might mean that this individual should get a different decision to what the system recommends. And so the problems that we're addressing here are around automation bias. So this is where people come to rely on, unquestioningly rely on the outputs of a system. And this can happen in the context of AI because it's often hard for people to interpret how a system has come to its decision, and therefore if they trust that it's going to get the right decision, then but they don't understand why, then they're not going to question it when it gets the wrong decision. So these kinds of issues need to be brought into your consideration during the design phase and the building phase. So ensure that you're going to be training human reviewers sufficiently, and if you fail to do that, then there's a risk of automation bias and a lack of interpretability. So I'll finish there and hand back to I think to Alistair.
I think we're handing over to Abby now. So thanks.
Okay.
Thank you both. So as Alistair and Ruben have discussed previously, the GDPR and Data Protection Act 2018 contain a significant focus on large-scale automated processing of personal data, and several provisions specifically referring to the information you need to provide to individuals when you use profiling or automated decision-making. When a decision is made about an individual using solely automated processing, the GDPR states that organisations should provide individuals with the existence of solely automated decision-making producing legal or similarly significant effects, meaningful information about the logic involved, and the significance and envisaged consequences for the individuals. This means that where you are making decisions about an individual, you need to consider how significant it is in order to determine what information needs to be provided. You should also consider whether the system you are using to make the decision about the individual will allow you to provide this information, and if not, whether there are any alterations you can make to your system to improve explainability. We'll provide some suggestions on how you can do this later in the presentation. You also need to think about how to inform individuals if their data is used at other stages of the AI process. For example, personal data used to train your model. In these cases, you will still be required to provide information before processing begins, as is required under Articles 13 and 14 of the GDPR, or when requested by the individual, as is required under Article 15 of the GDPR. You should ensure that the system you use is built in such a way that allows you to comply with these requirements. So now let's look at what the GDPR says in more detail. Articles 13 and 14 of the GDPR outline the information organisations need to provide when they obtain personal data about an individual. Article 13 outlines what information should be provided when the data is collected directly from the individual, whereas Article 14 details the requirements when data is collected from a third party. Both articles have the same requirements if you're processing personal data for the purposes of profiling or automated decision-making. You can read what these two articles say on the slide. Where decision support systems are used, or data is only used for training purposes, we would consider it best practice to provide this information to individuals where possible. You also need to comply with the other requirements under Article 13 and 14, which include providing the identity and contact details of the controller, providing information about the purposes of the processing, and providing details on the period for which the personal data will be stored. When considering the purposes of processing, it is important to note that this may differ for data used at different points in the AI system. For example, you may use data about several individuals to train your AI system, but another data subject's data may be used to make a decision about them. You should ensure that you consider all the ways that you're processing personal data when you provide information required under Articles 13 and 14. It is also important to consider how this information is presented to individuals. For information required under these articles, a common method for providing it is to provide a privacy policy to individuals. Based on the discussions we've held with industry, we suggest that you should consider building a layered privacy policy. By layered, we mean providing individuals with prioritised information in the first layer, and making additional information available on a second or possibly third layer. If you host your privacy policy on a website, you can use expanding section tabs or simply link to websites with additional information. The purposes of this layered approach is to avoid information fatigue. It means you won't overload people. Instead, they're provided with what is likely to be most relevant and important information, while still having clear and easy access to other explanatory information should they wish to know more about the AI system, process, or outcome. Article 15 of GDPR outlines the steps you need to take when an individual requests a copy of their personal data. This is commonly known as a subject access request. Article 15 also singles out automated decision making, and what is said about what it says is shown on the slide. As you can see, this is the same information as is required under Articles 13 and 14. However, when responding to a subject access request from those you have made decisions about, this allows you to provide more information about the likely consequences of the decision than you'd be able to provide in your privacy notice. This is because you should be able to provide detail about how the system made the decision it did and what the next steps would be. You should therefore ensure you're able to provide general information about your AI system in your privacy notice and more targeted information about a particular individual or decision upon request. Although, again, this only applies in cases where solely automated decision making, including profiling, produces legal or similarly significant effects, we would recommend that you consider providing this information where decision support systems are used, also as a matter of best practice. You also need to ensure that you are able to comply with all other Article 15 requirements, including providing information about the purposes of the processing, categories of personal data being processed, and how long the data will be held for, if possible. This information should be provided to the data subject within 1 month of you receiving the request in most cases. You therefore need to be able to locate and extract personal data quickly and easily. This applies to all data used within the AI system, including data used to train the model and data used to make a decision about an individual. We've produced detailed guidance about the right of access on our website. We recommend that you ensure that you fully document the data you hold and why you hold it to ensure you are able to fully respond to these requests. More information about how to do this can be found in Part 3 of our Explaining Decisions Made with AI guidance. In order to ensure you're able to provide the required information to an individual at the appropriate time, we would recommend that you keep your obligations in mind throughout the lifecycle of the AI system. In Part 2 of our Explaining Decisions Made with AI guidance, we outlined 6 tasks that can help you do this. These tasks take you through the elements of the system you will need to explain to individuals, from the building or procuring of a system through to delivering an explanation to an individual after a decision has been made. For example, Task 3 looks at different types of AI model and their advantages and disadvantages. It also outlines different types of supplementary models which can be used alongside so-called black box models in order to help explain how a system made a decision about an individual. Understanding how a system has made a decision helps you comply with Articles 13 to 15 and 22 of the GDPR, as it provides meaningful information about the logic involved in the decision-making process. However you choose to fulfill your Article 13 to 15 obligations to individuals, it is important to think of it as a conversation as opposed to a one-way process. By providing information, you are then initiating a conversation and not ending it. Individuals should not only have easy access to additional explanatory information, hence the layered privacy policy as outlined previously, but they should also be able to discuss the AI-assisted decision with a human being. However, as well as being able to contest decisions, it's important to provide a way for people to talk about and clarify information with a competent human being in order to fully comply with your obligations. I will now pass over to Ahmed to wrap up.
Ahmed, I think you're still on mute.
Sorry, that was a rookie error. So we are looking to get some of your feedback. So at the end of this webinar, you're going to get 2 surveys. We're looking for your views on an AI risk toolkit to help practitioners assess their system. So we've got that, and we're looking to get your views on the usability and effectiveness of the explained decisions made with AI guidance. And again, links to these surveys will be sent out after the webinar. Okay, so thank you for some of your questions. We're going to get to as many of them as possible. Please do like the questions so that we can hope we can use that as a way to order the way we ask them. So for the moment, I'm going to start with Stephen's question, looking at he asks, some AI decision making is made as part of wider processes of an organization and may not therefore be visible to the subject of the decision. It is therefore difficult for the subject to even know you could challenge. Should organizations be explicit that they are using AI to assist in making decisions? Probably say Ruben, Alistair, do you want to pick that one up?
Sure, I can have a go. Abby might want to come in on the information explanation side of it. So I think it is likely that in that kind of situation, you would already have had to inform people, particularly if their data is being used to train the AI system, because that would be a distinct purpose from any decisions that are made on the basis of it. So you certainly need to do that. As to whether you necessarily always need to say that you're using AI as such, that's not necessarily always the case. But that doesn't mean that you don't have to explain to them, all the other things that Abby mentioned. Yeah, I hope that makes sense.
Okay, thank you, Ruben. So I like the question here about from Anonymous. What if one wishes to purchase a list of contact details, names, etc. from company person in order to solicit business? What safeguards should be used by the purchaser prior to this purchase to ensure that the purchaser meets all of the requirements to ensure compliance with DP law?
I don't mind answering this. It doesn't seem too specific to AI, and it may, if you're using it to solicit business, the PECA regulations may apply here, and so you should consult PECA as well as data protection law. PECA regulates direct marketing and stuff like that. I think that's maybe where they're going from when they say to solicit business. I'm not sure. But yeah, so PECA addresses direct marketing, including when you need to get consent from the individual about that. What safeguards? I think just the general safeguards would be adequate documentation, which will include the contract with the purchaser, so ensuring that the purchaser is complying with data protection law. And part of data protection law would be the accountability principle, which is about complying with data protection law as well as being able to demonstrate that compliance. So the business that you're trying to purchase it off would have to demonstrate that they've obtained that data legally, and that they've made it clear to the individuals that they've collected that data, that their data may be passed on to a third party. And yeah, I think documentation and contracts is the key consideration there for that one.
Thank you, Alistair. There's a follow-up question regarding the question from Stephen. Any suggestions on how to explain what the AI does in that context? If we go back to Stephen's question. So frequently, actually, I'm going to move to another one so I can frame that one a bit down the line. Sorry. Let's go with another popular one. There's a lot of questions about insurance. I just want to get to more. Okay. Let's go with Jackie's question. Another difficult one, but let's see how we go. Are there sufficient safeguards via software as a medical device when deploying AI algorithms in the NHS? Very hard question. Can anyone answer that? Suspect not.
I mean, if the question is, are the existing safeguards in sort of medical device regulation sufficient for data protection purposes, I'd say no. I mean, they may be overlaps, but I wouldn't rely on them. If the question is about, say, Article 22.3 says, there need to be appropriate safeguards, and it lists some of them, and there may need to be others, and maybe some of the software as a medical device type rules and regulations might help there, but I don't think it would be sufficient from a data protection perspective. That's my opinion, but it would depend on the context.
Thank you, Ruben. Question here about, is it required to demonstrate that AI decisions are free of discriminatory bias? Is it a requirement?
I don't mind starting.
Yeah.
So as part of your data protection impact assessment, you'll be legally required to sufficiently mitigate the risks that your AI system, which could include the risk of discrimination, and it will depend on your organization's tolerance to discriminatory bias. So in some cases, it may not be possible to eradicate the risk of discriminatory bias in your system, and therefore you'll need to decide whether you'll tolerate that risk of discriminatory bias. Whereas in other cases, it may be possible to completely eradicate the risk. And is it required to demonstrate that you've done that? It's not required for you to publish your DPIA by data protection law, although the ICO recommends as best practice that you do publish a version of your DPIA. So it could be like a high-level overview of how you've mitigated that risk of discriminatory bias. And however, if in terms of how you communicate with the regulator, if the ICO was to assess your AI system, you would then be required to demonstrate how you've mitigated the risk of discriminatory bias in your AI system. And the ICO can take a view as to whether you've done that sufficiently, or whether there is a significant risk to individual rights there that would require follow-up action. So hopefully that answers that question.
Thank you, Alistair. Stephen asks, modern technology frequently requests users accept revised T's and C's. These are typically long and and occur frequently, so users rarely read them. If the T's and C's change to include data capture for AI, does the ICO think this is sufficient for consent as the alternate for the user to stop using their device? Abby, do you want to go?
I can have a go. I think it depends whether you're using consent as your lawful basis for processing to begin with. If you're not, then I guess this question kind of ends up being a little bit irrelevant. But if you are using consent, you do, if you're going to change systems to use an AI system, then I would have thought that you should make that clear to individuals if it is going to have an impact on them, especially if it's something that falls under sort of Article 22 type scenarios. I would have thought if you were going to change your terms and conditions to include the use of AI in those sorts of situations, you will need to make it more explicit to individuals than sort of just within your changing T's and C's, sort of maybe highlight more than just in the terms and conditions that you're going to do that. If anyone else wants to jump in and add, then please do.
I was just going to add the definition of like meaningful consent. I think that's partly what Stephen is trying to ask here, and if the alternative, well, if there isn't an alternative and users either have to agree to it or they can't use that device or service or whatever, arguably that would not be meaningful consent there because the individual does not have a clear choice there. So organizations should be mindful. If that is the case, organizations should probably try to choose another lawful basis for processing. Or if they do go down the consent route, then they should consider the different options that users can have. So if they can't use that service without, well, if part of the service is to include AI in some way, then there should be a clear alternative that users can elect without any fear of detriment of electing that option, to ensure that they can carry on using the service without the particular processing that the user doesn't want to use, have their personal data processed for.
Okay, thank you, Alistair. We're going to plough on. We've only got a few more minutes, so try and get as many in as we can. A question from Anonymous. What is the threshold for determining where automated decisions making starts and human decision making stops? Where is it a combination, or is it a combination of both that would cause Article 22 to come into effect? Alistair?
Yeah, so Article 22 only applies where the decision is solely automated. So if there's a combination of human decision making and automated decision making, then it's unlikely to come under Article 22. I think the important thing here to think about is the overall decision and the envisioned consequences and effect of the individual of that decision. So if the final decision before the effect of the individual takes hold is done by solely automated processing, and it has a legal or significant effect, then it's likely that Article 22 will apply. However, if there is a solely automated decision making, but then it goes through a meaningful human review, then it's likely to fall outside of Article 22. So yeah, the threshold is essentially who's responsible for the final decision before the effect on the individual takes hold. I hope that makes sense. I don't know if Ruben wants to come in on that at all.
Let's press on, Alistair. Oh, Ruben?
Sorry, I was on mute. Sorry. No, I don't have much to add. Just to say, I agree with Alistair. And if you think about it as has the outcome have certain possible outcomes been decided by the system? So if the human is making the final choice, and they have available to them all the different options of possible decision outcomes for the individual, then that wouldn't count. But if some of the options have already been closed off as a result of the automated system, then that would arguably be solely automated.
Okay. Going to go with a question from around synthetic data. Do you think that the use of synthetic data is recommended while training the AI before deploying it in the real world?
I'm happy to have a go at that.
Go on, Ruben, you want to start?
So yeah, I think there's interesting potential applications for synthetic data. I think in most cases, synthetic data, if produced in the right way, shouldn't contain traces of the original real data, which may be personal. So in that sense, it's outside of the scope of data protection, but it depends whether the synthetic data has the kind of statistical properties that would allow you to train a model which performs well in the real world. So certainly it's interesting and it could be useful in some contexts, but it's not a requirement, and it may not work in some contexts.
Maybe just worth adding to that, that the ICO is currently looking at producing some guidance on anonymisation, which I think part of that will include discussion about synthetic data and when synthetic data may actually fall under the remit of data protection law, i.e. count as personal data. So this work will continue on in 2021, so just to look out for that when it gets published.
All right. Probably time for a couple more questions. If AI is used to inform a human decision-making process by providing evidence, but not make the decision itself, to what extent is AI covered by the requirements that we've been discussing? Ruben.
Sure. So the main difference is, as we said before, if it's just informing a human decision, then Article 22 doesn't apply because it's not solely automated decision making. So everything we've said about Article 22 wouldn't apply, but I think everything else we've said would still apply.
Okay. Thank you, Ruben. There is a question here from Freya. Do you agree that insurers should make available all factors that they use for their risk assessments? Does anyone want that?
Yeah, I can start. So again, I think this calls back to an earlier question and answer. So as part of their transparency obligations, insurers may need to provide meaningful information about the logic involved, which I don't know, Abby might want to correct me, but I think that would include all the data that's used to produce the decision. So yeah, all the factors that insurers use. I think as well, if a subject access request was made, again, if the factors include personal data or data that picks out an individual, then again, yes, the insurer will need to provide that information to the individual.
I think part of what we say in the explain guidance is that although organisations do have to provide meaningful information about the logic involved, and they will have to publish some of the sort of provide some of the information about how they make decisions, we wouldn't necessarily expect organisations to provide information that would allow people to game the system or to give out any intellectual property type information. So there is a balance that can be made between providing enough information to help people understand how a decision is made about them, but also holding some information back if you feel that it could affect how your organization actually runs and how your system operates. I'm sure Ruben has more information about that sort of process too. Maybe not.
Well, just because we're overrunning now, we'll stop there. Thank you all so much for your questions. Just to reiterate, there's going to be a couple of surveys coming out to you post this webinar, so please do fill them out. Handing back over to you, Suzanne, to finish up.
Thanks very much, Ahmed, and thanks everybody for an interesting discussion there. Yeah, I'll send the emails this afternoon with links to the surveys, and if you would all be so kind as to provide a little bit of feedback, there'll be a link in there in the email as well. I think that's it for today. Thank you very much, everybody, and thanks for joining us. Take care now. Merry Christmas.